workers' compensation settlement agreement, when an accident that materially aggravates a pre-existing condition, but that pre-existing condition is the subject of a previously approved compromise settlement agreement, it does not constitute a separate compensable injury. The Industrial Commission, the full commission, said that no, a material aggravation is a separate compensable injury, but they provided no authority for that statement. And our contention today is that that statement is contrary to 9717, the statute that allows for compromise settlement agreements, and in fact the purpose, the point of compromise settlement agreements.
Do you agree that a material aggravation of a pre-existing injury, generally, absent the clincher, if caused by an injury by accident, constitutes a compensable injury?
Yes. I think that if this had occurred at a different employer and he then had transferred to Wieland, then we would be responsible for it. The difference here is our contention is that material aggravation was essentially bought with the compromise settlement agreement. And that's what makes it different than, I think, the scenario that you're presenting.
Yeah. And so with the clincher agreement, if this was an injury to a different body part, would it be your contention that the clincher covers a different body part?
You smash your right hand in 2009, clincher that thing. 2020, you smash your left hand. I think I just switched my hands, but nonetheless, the clincher would not cover a separate body part or a separate injury. That's our contention.
What about a new injury, sort of new mechanism of injury to the shoulder, to the arm here? You know, like if it was a fracture of an arm, would the clincher cover that versus?
So we have the shoulder injury we have here, and then he fractures his arm,
or fractures the shoulder. Sort of a different mechanism, different type of injury, different from like the rotator cuff injury. Would that be covered by the clincher?
I think that it could. I mean, again, we're going to start. I do think that there's going to come a time where how granular we get with what a new injury is and what actually causes it. I mean, and I don't understand the anatomy of the shoulder all that well, but I think there's like 4 muscles. You know, I suppose an argument could be made that if, you know, 3 of the muscles are, and I don't even think this is possible, but 3 of the muscles are torn, the 4th one is perfectly fine. The plaintiff were to do something and pop that 4th muscle, you know, I certainly think there would be an argument that would be a new injury, and it would certainly, the clincher agreement would not cover that. But that's not what happened here. And again, there is some sort of an argument over whether a new injury occurred. The full commission didn't find it. And I think that, I mean, again, in my opinion, the testimony is overwhelming that this was not a new injury. This was absolutely clearly a progression of the pre-existing injury, which was clinchered.
Sort of change of condition, would that be the term?
I think we use that term in our brief, and you know, I'll be honest with you, change of condition is a specialized term. It's governed by 9747. I don't know that I put a lot of thought into whether I was just using his condition changed, or such as a change of condition. Or actually
right. I mean, we're focused on whether this was an aggravation of a pre-existing, I guess.
What I will say, and I'm just speculating here, plaintiff's counsel can clarify it, but so when I said that the Industrial Commission provided no support, I also don't believe that plaintiff's counsel in his appellee's brief put forth any support that a material aggravation of a pre-existing condition that's been clinchered constitutes a separate compensable injury. I think in one of the cases that he sent up in his memorandum, the Moore case, maybe kind of starts to flirt around with that, and it uses that term change of condition, an injury in 92. I think that the statute would have prevented a change of condition claim, So maybe there's some tension there or something that if that case, the difference between a change of condition and a material aggravation, you know, I don't think ultimately it comes to that. And again, I'll let plaintiff's counsel explain his own case, but if you're going to focus on change of condition, that's what I would say is this change of condition was bought and it's gone. But also, if you look at the settlement agreement, this is in your documentary exhibit 708 is where it starts. But when you go to 717, the last paragraph, the statement 9747 is not in there, but that closes out a change of condition. But the paragraph up above, again, a separate paragraph, sort of talks about anything that would also clinch or any future things that may not follow under the technical definition of a change of condition. And again, this last paragraph is specifically put in there for 9747. And Judge Hampson, I got off on a tangent there. I don't know if that's where you were going, but you said change of condition, and I wanted to address that.
Right, I'm just trying to trying to build out the parameters here, so that's helpful. Thank you.
Right. And so again, and I do think it's crucial that there was no new injury. So your hypotheticals notwithstanding here, I don't think that that's what occurred. There was something in a medical note about a new scap tear. The full commission made a finding in I think it's finding fact 32, but that's not really a finding of fact. They're just reciting the evidence. And that new scap tear is explained with Dr. Janeway throughout his deposition. In fact, on page 64, he clearly says no new injury occurred. This was a continuation of the previous injury. This was a progression. It was on a continuum. And again, I do think that's crucial here is that no new injury occurred. So in 2009, he hurts his shoulder. Mr. Collins does. The treatment does not go well. There's 2 surgeries. Neither one worked. He gets around to 2013, and Dr. Supple talks to him about, look, your shoulder's not good. I don't know if there's anything else we're going to do to drastically improve it now. It's just going to get worse. Eventually, you're going to have a shoulder replacement. And I think all this was agreed to by Dr. Janeway. But nonetheless, you're 49 years old. We don't want to do that right now. You're too young. Let's see if we can just manage it. But he knew that the shoulder was going to continue to deteriorate, and most likely he was going to have a new shoulder surgery. So at this time, he's got options. It's a compensable claim. He can keep his claim open. And at that time, the employer and the carrier would be responsible for all of his medical treatment for that shoulder. And if that treatment ever resulted in disability, had to go out of work, the carrier would be responsible for that. He could also apply for sort of like usually there's a 2-year gap. So if you go 2 years without seeking any medical treatment, your rights are barred. But you can go to the Industrial Commission, you file a Form 18M, they grant it, and they waive that 2 years. Because in a situation like this, where it's clear the doctors are saying, you are going to need this surgery, I don't know when it's going to be. Maybe in 2 years, maybe in 5 years, maybe in 10 years, but you're going to need it. So you get that 18M, and then you don't have to go back to the doctor every 2 years. He could have done those 2 things, or he could have done what he did, which is he accepted, we contend $100,000. The total settlement was for $125,000. It was a difference of a rating. The 2 doctors gave different ratings, but essentially $23,000 for a rating that he was going to get. He could have accepted that. So again, essentially $102,000. What was that $102,000 paid for? Why was that money given to him? It was given to him to compensate him for this unknown risk that we're pretty sure it was going to incur of the future medical treatment, the future surgery, and whatever disability that he was going to have.
But doesn't that sort of conflict with the differing contentions in the clincher agreement itself? Where your client says, nope, it's back to work.
There's a difference of opinion. Obviously, he is back to work. He is not he is earning money, so he is not disabled at that time. So our contention would be you're fine. He's not seeking any further treatment at that time, so you're healed, you're good. His contention is, I think we used the phrase lifetime injury, which again is reflected in the medical notes and Dr. Supple saying you're going to need this. You know, your shoulder is, we're going to try to manage it now, but it's not better. So these contentions are just sort of, in general, when I used to draft them, I mean, you just come up with the ideas that were there. The employer says you're fine, the employee says, no, I'm not. So that to me is what those contentions are. And I thought the full commission was a little bit picky when they started picking apart that language and also picking apart, well, I don't know what the $100,000 could, you know, it can't be for future compensation because he returned to work, and that's just not true.
Well, and there were sort of two components, right? Because you've got the Medicare set-aside, which is clearly for some future medical expense.
Right. And normally, I don't even know that and here it was specifically $25,000 was set aside for future medical treatment. Now, again, that was done because normally it'd be $100,000, and there may not be any differentiation. Sometimes there's a differentiation, sometimes there's not. Sometimes the plaintiff wants more for indemnity or maybe less for indemnity because it affects Social Security. But here, yes, he was 49. It didn't meet the thresholds that Medicare required, at least at that time. But sometimes out of an abundance of caution, you would just set it aside. And clearly, no one can deny that we are giving you money for future medical treatment, and we're giving you money because this injury may take you out of work again. And he is, again, accepting money for those two things that have not happened and may not happen or may happen far greater than $100,000 would compensate him for. So that's what the settlement was, and again, important, it was approved by the Industrial Commission. It's wherever the clincher is, 707, at the end of the clincher is the approved order for that clincher agreement. So the Industrial Commission reviewed this settlement agreement, reviewed all of the medical records, and said this is a fair and just settlement. We'll approve it. You know, again, we understand that you are compromising risk. The employer is trying to buy risk for less money. You're trying to take money, and maybe those risks won't come to be, or they'll come to be so much later so that this money is worth more to you right now. So the full commission, though, again, I think that, again, like I said, they did not justify, did not provide any authority for, you know, this is a new injury, but they dismissed this contract because of 97.6, which says that you can't contract away for future benefits. But the last sentence of that statute that reads, except as herein otherwise expressly provided, and you go to 97.17, and our legislature has expressly provided otherwise, you can make contracts to close out your workers' compensation claim. Every clincher, every compromise settlement agreement is a compromise of future benefits. You are giving up your rights to future workers' compensation benefits. You are giving up your rights to a change of conditions. You are giving up your rights to, if that injury, you know, goes south and becomes debilitating again, you are accepting money today and excusing the liability of the insurance carrier. So you're always doing that. I don't know that I completely understand.
Well, I think your colleague would argue that's all true and well and good, but what you can't contract away are your rights under the Workers' Compensation Act for a new injury by accident.
A new injury by accident. And again, I think that's where obviously the rub of this, the whole thing that we're talking about is a material aggravation significant enough to constitute a new injury, is a material aggravation of your same shoulder injury that you had before, the same as smashing your right hand when you smashed your left hand 10 years ago? Or is it the same as smashing your left hand twice?
And the Industrial Commission made findings that would support at least the accident component of that.
Support the act, yes. Again, I disagree that it was an accident, but that's just my personal opinion before you today. It was an accident. We're not appealing that. So yes, that is correct. But again, accident and injury are two separate things. You can have accidents all day long, maybe you don't have an injury, and here, this was an accident that did not result in a new injury. It resulted in a material aggravation of a pre-existing injury, and a pre-existing injury, the future liability of which was bought, settled, compromised in 2014.
So just to be clear for us today, are there any specific findings of fact that you are challenging as being incorrect made by the Industrial Commission?
They're in the brief, and I don't think that there are very many, but I don't think that we had to. Again, they never found that there was a new injury, so we're not contesting those. I think that finding of fact, I don't know, my recollection now is they actually never even talked to anything about the clincher being not set aside or 97.6 until they got to the conclusions of law. So again, I don't contest that there was an injury by accident. I don't contest that accident materially aggravated the shoulder condition. But again, I think that my opposing counsel made a big deal that we had waived some arguments. I just don't see it. I don't think there are any findings that we failed to challenge that are relevant to the issues. I think that he sometimes would say that we failed to challenge conclusions of law, but I recollect every case that I've read since 2002, you don't have to challenge conclusions of law, that they're going to be reviewed de novo anyway. So does that answer your question, or
Yes,
is that what you're getting at?
It does, yes, thank you.
I mean, I'll stand by the brief. Whatever we've challenged, we've challenged. Whatever we haven't, we haven't. So just to make sure that I cover this, at the end of the appellee's brief, plaintiff's counsel, indicated that this would have a chilling effect on workers' comp, that settlements or whatnot, or no, it would have a chilling effect, and that employers would, I guess, overrun employees with bad deals and con them into contracting out their future benefits. I would say that the opposite is true. If you affirm the full commission, I think it has a chilling effect on settlements with employees. And again, when you go back to the Workers' Compensation Act, what's the purpose of it? One of the main purposes is to return these employees back to work, as close to where they were before as possible. And usually that's with the same employer. You want to take care of your employees, they get hurt, you want to get them rehabilitated, and at all possible, bring them back to work for you. That's how the system works. Here, you're pretty much telling the employer, your guy gets hurt, you can clincher out your claim, but if you bring him back, you may pay for the injury 2 days after he comes back, 5 years after he comes back, 10 years after he comes back. I don't know why employers are certainly going to pay a lot of money to settle out claims and bring the employee back, so you've got to make a decision. You either settle it and he leaves, or he stays and there's no settlement. And again, I do think that compromise settlement agreements are beneficial. They work. The Industrial Commission mandates them anytime that it's going to go to a hearing. In this case, I don't think anything was going to a hearing at that time, so I don't know that his settlement was mandated. But again, my clients in 2014 paid Mr. Collins $100,000 for his shoulder injury. And if it wasn't so that they didn't have to pay it today, I don't know what else the $100,000 was for. It was to pay him for when he was only owed $23,000 at that time. So again, I don't know what, I think that the employer should have that incentive. And again, we pointed this out, I think, in the reply brief, the Teledo case, the only case that actually talks about 97.6 and 97.17, it talks about that, yeah, that was one of the concerns was, yeah, employers, the whole point of 97.6 is employers are going to try to hoodwink employees and make them sign away their workers' compensation benefits when they sign on to employment. I'll give you $100,000 but we're not going to give you workers' comp, you foreclose. All right, that's clearly not possible, or not correct. But again, the Teledoc case talked about how 9717, though, already has that built in because it's going to have to be approved by the full commission or the industrial commission. So that's sort of the safeguard. We're going to let you contract away your rights here. In this scenario, employers aren't going to be able to get one over on the employee because they're all going to be reviewed by the full commission, or the industrial commission, excuse me. And again, not in the record, you can disregard this if you want to, but and if plaintiff counsel disagrees, he's welcome to. In my practice with the people who practice, Mr. Collins was pro se when the settlement agreement was entered into. They look at pro se settlements a whole lot more closely than they do, when the employee has counsel. So, and I think there's one of the cases I cited in my brief says that their duty is to review it and review everything. In pro se cases, I think that was done. It has to be done. That's what their duty is. So, again, the Industrial Commission signed off on it in 2014. The $100,000 was clearly for the deterioration that we knew was going to happen. And I think that settlement agreement, again, forecloses this particular incident because it did not result in a new injury.
So is there specific language in the clincher agreement you would point to that specifically forecloses compensation for material aggravation of the injury?
That language is not in there, not a specific language, certainly not material aggravation that occurs if you continue to work with us. No, it does not. But I think that the language in there is broader than the language that you just said. So, and that's, I think it's in there 3 times, but certainly the last 2 paragraphs, the paragraph I specifically referenced on 97, the change of condition, the paragraph above that, and at least at one other paragraph, that you are giving up all of your rights for compensation for the injuries that are subject to this claim. So I think, again, that language, you don't have to put in materially aggravated, slightly aggravated, that forecloses it out. It doesn't foreclose out new injuries. And again, I think your point about that is well taken. And I do think that, again, at some point in time, I can't fully answer your question as to what component of a shoulder injury is a new injury and what component is an aggravation. But the testimony here, there was no new injury. I'm in my rebuttal time, but I'll be happy to spend that in answering questions if you have them now.
Thank you.
May it please the court, my name is Michael Hummel from Daggett, Schuler, in Winston-Salem, Forsyth County, and I'm here on behalf of the plaintiff appellee, Mr. David Collins. David Collins, at the time of the injury, was a 37-year employee of Wieland Copper. Before you today, he has 2 separate compensable claims for injury to his right shoulder. One happened in 2009, which was settled. That claim is settled. That agreement was enforceable. No one is here to set it aside, and no one has moved to set it aside. 9717 is a proactive statute. It has never been raised until this court. It was not raised in the issues in the pretrial agreement. It was not raised in the Form 44 appeal to the full commission. It was not raised in the brief to the full commission. It was raised here. It's not even actually in the issues identified in the record on appeal. He also has a second compensable injury of accident, which occurred on November 24th, 2020, which was found compensable by the North Carolina Industrial Commission. The conclusion that he sustained a compensable injury of accident on November 24, 2020 was not challenged in an appellant in the brief at any point. To your question, Judge Flood, there is no finding of fact or conclusion of law they challenge regarding the fact that he has a compensable injury of accident on that date. Even if this court were to find that it was somehow challenged and is an issue to be addressed, there is ample competent evidence in the record to support the findings of fact, and that those findings of fact would support the conclusion of law. Dr. Janeway, who is the physician who we've talked about a little bit today, was the physician who is in, frankly, one of the most ideal situations I've ever seen treating a workers' compensation patient. He operated on this man's right shoulder years before this injury by accident and years after this, not years after, but after this injury by accident. He has intimate knowledge of this man's shoulder. His testimony was that it materially aggravated a pre-existing shoulder condition. It matters not that that pre-existing shoulder condition was from a prior workers' compensation claim with this employer or other. This court has repeatedly refuted the argument that the pre-existing condition has to come from some outside source. In both the cases that we have cited in our memorandum of additional authority, Moore and Art, those injured workers were injured and had pre-existing conditions from work. They are still entitled to a subsequent injury by accident if they satisfy all the elements of the claim, if that injury by accident materially aggravates and exacerbates their condition, which is the case here. I would note that counsel for Appellees, at one point in their argument basically stated, well, the question is material aggravation enough for there to be a new injury? It is, because the Industrial Commission found it, competent evidence supports it. The only two physicians who have ever actually examined him, Dr. Supple and Dr. Janeway, both gave that testimony. And I would further note that on page 16 of the appellant's initial brief to this court, finding of fact 42, the full commission found that plaintiff's 24 November 2020 workplace injury materially aggravated and pre-existing shoulder condition. Defendants do not challenge this finding because that is the testimony of both Dr. Janeway and Dr. Supple, and thus the finding is supported by the competent evidence. So now we have two separate workers' compensation claims. Accidents not challenged, we talked about that today. No dispute at any point in time that it was in the course and scope of his employment. Now, one of the things I think has made this a little more confusing, and I think that the appellees have made this confusing, is when they use the word injury, they're essentially using it in a generic term, the way we would talk about it as we were walking down the street. Is this a new injury? Not, is this a compensable injury by law? Injury in the workers' compensation law is a legal term of art. It is defined under 9726. It is an injury by accident arising out of and in the course of someone's employment. It is the elements of a compensable claim. Here, there is a new injury, but you can call it a claim, you can call it an injury, but don't mistake that a compensable injury is the way injury would be talked about as the appellees would have you.
But I think the argument is more that this injury, because it's a material aggravation, flows directly from the 2009 injury. And there was a clincher which sort of presumed and covered future medical expenses and disability arising from that. And then in addition to that, Mr. Collins not only waived his right to come back within 2 years and do change of condition or additional medical expenses, that kind of thing, but also as it related to any future deterioration of the shoulder, whether that was a change of condition or aggravation or whatever you want to call it, that this settlement, the $125,000, covered the shoulder, period.
It covers the shoulder for that claim. And change of condition is 9747. It deals with the natural progression of an injury. You have 2 years after the last payment to come back and say, hey, there's been a natural progression.
And that's kind of, based on what was in the clincher, like that was sort of the progression from 2009 until the clincher. It seemed like there was just sort of an ongoing deterioration of the shoulder, starting at maybe 20% PVD, ultimately somewhere between 30 and 35.
Right. And a change of condition would come into effect if someone is just, appellees are essentially trying to argue that, hey, their shoulder just got worse and this is why they needed it. It does not apply in this situation because this is a separate claim. They cannot waive the right to a separate claim. This court has repeatedly refuted the suggestion that although there may be some causal connection to plaintiff's original injury, plaintiff's current back problems were the result of the subsequent injury, which substantially aggravated pre-existing back condition. That's a quote from Moore. It does not matter. Employers take their employees as they are on that day. If someone has a compensable injury on that day, well, they're entitled to benefits for that claim of injury. They're not seeking benefits on a prior claim of injury. At no point in time has Mr. Collins sought to reopen this 2009 claim. It's nowhere in the record because that's not what this is. And that is what the appellees would have you ask. What we have litigated from the outset of this claim is there a new compensable injury by accident? And if there is, that employee is entitled to benefits under the North Carolina Workers' Compensation Act for that injury by accident. 9717 does not apply if there's a new compensable injury by accident, because it does not matter what the prior clincher says. We have a new compensable injury by accident. They did not contract away the right for an employee to have a future workers' compensation claim. Yes, natural progression. Yes, is he going to have, because he has natural progression, hypothetically, would he have had to have the shoulder surgery in 2016 or something like that? Sure, those things would have been barred by this contract. This is not, because it's a new claim. The Dr. Janeway basically said, the reason he's having surgery now is because of this incident at work. And as such, this is a compensable claim for which he's entitled to new benefits. What the appellees are essentially asking for is you to use a contract that no one has challenged. Again, Mr. Collins acknowledged that that's a contract. If the full commission found that was unenforceable, as the appellees are suggesting, he would have had to pay back all that money. That didn't happen. That's not what they're saying. What they're saying and what the law says is you cannot use a contract to avoid your responsibility to your employees for workers' compensation claims. That's specifically stated in 97.6. Appellants in their brief suggest that 97.6 only applies to contracts that arise outside of the Workers' Compensation Act. They say basically it arises to, outside contracts. That is not what 97.6 states.
But certainly, even on that argument, clearly 9717 provides that an employee can contract away some rights under the Workers' Compensation.
Yes, absolutely. That claim is closed. That 2009 claim is closed. It was settled. It was settled long ago. And everyone who was a part of that contract, Wieland, Mr. Collins, and a prior workers' compensation carrier, there's a new compensation carrier on the risk, which, it raises a whole host of other issues, and maybe why we're here. Everyone's a part of that contract. That contract's enforceable. No one has sought to set it aside. No one has challenged it. No one has said it's unenforceable. He did contract away the rights to further workers' compensation benefits for the 2009 claim, to reopen that claim. This is a 2020 claim. You cannot contract that away because 97.6 specifically states.
So the clincher, though, provides in the sort of the next last paragraph that essentially, I'll paraphrase, but releasing the employer on account of the injuries which give rise to this claim for compensation or for any work-related injury claim filed, unfiled, and for any subsequent disability sustained by employee plaintiff for medical bills incurred, again, whether known, unknown, filed, or unfiled. That seems like pretty broad language. How do you address that?
That is very broad language, and it releases just about anything you could file for that prior workers' compensation.
And this was approved by the commission?
Yes, approved by the Industrial Commission. Again, the Industrial Commission has reviewed that. They've approved that. They have heard this case. They have never set that aside. They have never said that doesn't apply. It's an analysis in 9717 does not come up in this case because there's a subsequent claim. He's entitled to benefits for a new claim. Yes, he has waived those rights to that prior claim. No one is disputing that his shoulder had pre-existing conditions because of a 2009 injury for which he settled. But again, that does not preclude him or prevent him from being entitled to benefits under the North Carolina Workers' Compensation Act for an entirely separate claim of injury that this court, that the Industrial Commission has found and frankly is unchallenged at this point in time. It is very broad language, but you cannot waive a right of future claims. Appellees would essentially have you read into 97.6 that prior workers' compensation claims can allow an employer to avoid their responsibility for all subsequent future claims to their employees, regardless of body part, anything else. That's what they would have you read into it. Statutory interpretation does not allow us to change the language which the legislator has laid out. The Tolado case, I would point out, which is cited by appellants in the brief, basically says North Carolina General Statutes 97.6 and 17 are enacted as part of the North Carolina Workers' Compensation Act in 1929 to protect employees from employers who would try to circumvent the act. That's what this really is. An attempt by an employer to use a prior contract for a prior claim to avoid a new compensable claim which has been found, which is competent evidence supports, which justifies the conclusions of law, in which this Mr. Collins is entitled to new benefits under the act.
What is your contention as to what the $125,000 settlement actually covered?
The clincher, as is laid out, indicates that there are impairment ratings at issue, that there are there's an amount of money allocated for future medical treatment, which will be covered by Medicare, if and when he is covered by Medicare. He was younger then and wouldn't have been for many years. There probably would have been considerations for times out of work if there would have been a natural progression that wasn't caused by a separate workers' compensation compensable claim, future medical treatment that wouldn't be covered by Medicare. There's any number of things. A workers' compensation settlement is really an indeterminate amount of money. They do not spell out this is for X, Y, or Z for the most part. What they do is they settle a claim on whole. And as you rightly pointed out, there's contentions in there. There's disagreements in there. That is a bargain for amount of money that was entered into by Mr. Collins, Wieland Copper, and this other workers' compensation carrier who's not a party to this claim. It has no bearing on whether or not he has a new claim. To have a new claim, he has to meet the elements of injury by accident, which is defined by our statutes. It doesn't matter how much money that Wieland Copper and the prior workers' compensation carrier offered Mr. Collins. The amount of money they are offered in a prior claim does not matter as to whether or not someone's entitled by law to have a claim for an injury that occurs in their employment. They cannot offer over X amount of dollars and say, well, you know what? We're absolved of all legal responsibility for any future claims you have. That's not in there, and you can't do that. The appellants indicate in their briefs that essentially the full commission said that the clincher was unenforceable as a matter of law. That's really kind of a misstatement of what they said. That's a partial quote. The industrial commission did not find it unenforceable. They basically indicated that as the way the appellants would try to use it, to use this former contract to bar a future claim, then it would be unenforceable. The language you cite would be unenforceable because our statute simply does not allow it. It is notable that the appellants did not cite a single case or authority which supports what they're really seeking. They cited a whole host of cases that include the analysis of 9717. In every single one of those cases, someone was trying to move to set aside a compromise settlement agreement. They were trying to find that contract unenforceable and avoid themselves the responsibilities or the release of that compromise sum agreement.
But and correct me if I'm wrong and if I'm missing something, but I don't think either party has cited a case that specifically addresses this particular scenario. So, I mean, it's not necessarily a compelling argument to say the other side hasn't cited a case that controls here. Well, neither has.
You're right, Your Honor. We have not cited a case, but I have the statute that does. 97.6 is a clear statute. Statutory interpretation says you cannot use a contract to avoid your liabilities under this act. They can't get around that. There's not a case because, frankly, no one tries to use a prior workers' compensation claim to avoid any workers' compensation claim. I'm not aware of anyone who's gotten to this stage yet, frankly, to do that. But it is clear from the cases that have been before this court that you can have material aggravations that are new claims of injury to the same body part, even if that pre-existing condition came from a work-related injury. You can injure your back, have a workers' compensation claim 5 years later, have an injury, a specific traumatic incident, which aggravates that back. You're still entitled to benefits for that new claim. There's nothing that prevents that. That is what they are arguing here today. No one is seeking or is found to reopen this claim, as the appellants are essentially arguing. They're basically saying this is a reopening. It is not. Quite frankly, appellants on their argument basically said in their clincher, that Mr. Collins waived all the rights and compensation he would be titled subject to this claim, when he was referring to the 2009 claim. And that is it. He waived his rights and responsibilities to that 2009 claim. This is a 2020 claim. No one has sought to reopen the 2009 claim. No one has sought to set aside a clincher. What we have sought are entitlement to benefits under a set of laws that allow people to have workers' compensation injuries. That is why we have the laws. They're entitled to compensation and medical treatment for claims of injury where someone is hurt at work. Now, that material aggravation, once that's found, and again, unchallenged by the defendants in the brief, acknowledged, unchallenged, means that that material aggravation, that condition that employee now has, arises out of this new claim. You can no longer point to the prior claim, the prior incident, whether it happened at work, whether it happened in their backyard. You cannot point to that anymore. Once material aggravation is found, the law says that that condition now arises out of that claim. Mr. Collins' condition, for which he had the total right shoulder replacement, to which he has been written out of work, to which he is entitled to benefits under the law, arises out of this November 24th, 2020 injury by accident because there was this material aggravation. We ask that this court affirm the decision of the North Carolina Court of Appeals that Mr. Collins sustained a compensable injury by accident on November 24th, 2020, and that he is entitled to benefits thereby. I'm happy to answer any questions. I know I've kind of talked about this a little bit at length, but I want to reserve time for any questions the panel has. Thank you for your time today.
Appreciate it. All right, we'll hear from the appellant on rebuttal.
Thank you again, Your Honor. I'm just going to quickly try to make some clarifying statements, not necessarily any further argument, at least not at first. And you are correct. Neither side has given you a case that you can point to and make the resolution of this need, because I don't think they exist. I certainly think that we look for the cases in our briefs or the best cases that we could come up with to help guide you. I can't exactly remember exactly how counsel put it, but I want to be clear that what we're saying is that you cannot make a separate claim for the same injury that was subject to a previous claim that was clinchered. And I know we're getting into words here of what constitutes a new claim. I mean, is it an aggravation? Is it a new injury?
And so at some point, this is kind of a fact-finding exercise, and we kind of defer to the Industrial Commission.
And again, my argument is going to be that it has to be a new injury, and there's no evidence that it was a new injury. If you want to hold that a material aggravation constitutes a new claim, then I suppose you can. I don't know what authority you're going to use to support that. The full commission didn't give you any, and I don't think that plaintiff's counsel has given you any. I don't think that you can rely upon the Moore case. I don't think that what he says is actually the holding. I think they refer to something that, if you can find it in a previous case, perhaps you can hang your hat on that case, but I don't think that it does. And then the ARD case, again, and again, neither one of those cases, again, are really going to get you to where I think you should be, because, again, no case is out there that deals with a compromise settlement agreement, and I do think that that is the difference between this case and Moore and ARD, is that there was a approved compromise settlement agreement. Plaintiff's counsel, again, says that I can't get around 97.6. Well, I can. You go to the last sentence of 97.6, and it says, except as herein otherwise provided, and 97.17 provides how I can contract away for future benefits as long as it's the same injury. So, yeah, that's my statement. I think I'm around it, but he also said that I made some broad statements about 97.6. We can opine about 97.6 all day long, but what I want to say is that 97.6 cannot prevent a contract that arises under 97.17 that has been approved by the Industrial Commission. So that's the only thing I'm really saying today. I reserve the right to argue different things about 97.6 later, but 97.6 does not prevent parties from entering into a contract under 97.17 that have been approved by the commission, and yes, within those contracts you can compromise, settle, get out of your rights for future compensation for the same injury. And I think, Judge Hanson, I think you and I kind of did this before, but again, just to be clear, I am not arguing that our clincher or any clincher gets the employer out of a new injury. That we can't do. But the facts here, I do think material aggravation is not enough to get you there, and that's what the evidence shows. I mean, I've conceded that there was a material injury, a material aggravation of a pre-existing condition. I say that a new injury cannot get you there, cannot get us out of that contract, but that's not what occurred, a material aggravation, and that does not give you enough. You cannot make a new claim again for an injury that you've already clinchered out. And just the last thing, I want to be careful because I'm going to say something that I don't really think that we should, it's hard to look at. I don't think that you should look at clincher agreements and the amounts paid retroactively, because obviously in every settlement agreement you're looking prospectively, and probably every clincher agreement that I've ever drafted, if you went to that employee today and said, did they give you enough money, they're going to say no. So again, I don't think that, again, looking back at the value of it is a little bit construed, but the value has been brought up, and so I would say that, $100,000 in 2014, what was that money for, if not for this? He hasn't missed any time from work, and he hasn't really had any medical treatment. So what did we pay $100,000 for, if not to, and again, when you take risk, certainly you can get a windfall, and I'm not trying to accuse him of that, he sort of manipulated a $100,000 windfall, but I can say that $100,000 has not been spent on a workers' compensation claim that we would have otherwise paid for. And like I said again, that might be a poor illustration, and I won't be held much to it because I don't think that you can really, you can't make any conclusions based upon that, but I did want to point it out. That's what I have. If you have no other questions. All right.
Thank you.
Thank you.
Appreciate the good arguments of both counsel, and the case will be submitted. And with that, I believe we're ready to adjourn.
All rise. This session of the North Carolina Court of Appeals is adjourned.